Welcome to the WPS Military and Veterans Health TRICARE for Life HIPAA and Privacy webinar. The Privacy Act of 1974 is a federal law that was established to provide a safeguard for individuals against invasion of personal privacy. The Privacy Act imposes legal responsibility on TRICARE for Life to ensure confidentiality. The HIPAA privacy rule lets medical staff use and disclose your protected health information, or PHI, for treatment, payment, and healthcare operations without written authorization. Your permission is required for most other uses and disclosures. The Military Health System, or MHS, Notice of Privacy Practices is a notice that explains how the MHS will use your protected health information, when and where the MHS may disclose your PHI, how to limit where the MHS will disclose your PHI, and how the MHS will protect your PHI. You can access a copy of the MHS Notice of Privacy Practices on the Military Health System's website. The URL is displayed here on screen. PHI stands for Protected Health Information. Under HIPAA rules, PHI is information in any format, electronic, paper, or oral, that is created or received by or on behalf of a covered entity. A covered entity is a healthcare provider that conducts standard electronic transactions, a health plan, or a healthcare clearinghouse. PHI relates to the past, present, or future physical or mental health conditions of a beneficiary, the provision of healthcare to a beneficiary, or the past, present, or future payment for the provision of healthcare to a beneficiary. And it identifies a beneficiary, or it could be used to identify the beneficiary. Information covered by the Privacy Act includes, but is not limited to, Social Security numbers, home addresses and telephone numbers, race, diagnoses, medical records, and medical photographs. The HIPAA privacy policies and procedures sets boundaries on employee activities relating to PHI by detailing the specific practices that are allowed and those that are not allowed with respect to requests, uses, and disclosures of PHI. Each member of the TRICARE for Life workforce and each of TRICARE for Life's business associates is obligated to follow these HIPAA privacy policies and procedures. TRICARE for Life must obtain authorization for use or disclosure of PHI. For more information on HIPAA privacy and PHI, please visit the URL seen on screen. Information can be released to beneficiaries, network providers, spouses, or other family members with authorization on file, attorneys representing the beneficiary, and parents of children under the age of 18, and parents with sole or legal custody. You can give authorization on a call-by-call basis. You would have to be on the phone at the time of the call to customer service and give verbal permission for our representative to speak to the person you choose to represent you. It is important to note here that you need to give authorization on every call if written authorization is not on file. You can contact customer service at 1-866-773-0404. A better approach is to give authorization to release information in writing. You will need to fill out an Appointment of Representative and Authorization to Disclose Information form and submit it to TRICARE for Life online or by mail at the following address: WPS TRICARE for Life, P.O. Box 7889, Madison, Wisconsin 53707-7889. The form can also be accessed online at TRICAREforyou.com. If you are not a registered user, you can download the form and print and submit the form by mail. If you are a registered user on TRICAREforyou.com, you can also grant access to a family member for that person to see your personal information online. The family member must also be a registered user on TRICAREforyou.com for this feature to work. Log in and go to the Family Profile area. From there, you can request access from a registered family member or grant access to a registered family member. Once access is granted, your family member will be able to see your claim information in his or her account and you will be able to see his or her claim information in your account. If you are not a registered user on TRICARE4U.com, please create an account now. Without an authorization on file, we cannot release information to unauthorized family members, parents of children over the age of 18, grandparents, step-parents, collection agencies, and other health insurance companies without authorization from you to do so. If there is a will, which is a legal document containing instructions as to what should be done with one's money and property after one's death, or an appointment of executor, executrix, or personal representative, this information cannot be released unless the person is deceased. An executor, executrix, or personal representative has all the same rights as the deceased person. Sometimes this can be more than one person, and all have the same rights to the information. If power of attorney, or POA, or guardianship papers are received, we need to know if they are intended for release of information as well as designation of payee. For a power of attorney to be a legal document, it must be signed and dated, at a minimum, by the principal, the grantor or donor. Seek legal counsel to ensure requirements for an effective power of attorney are satisfied. If the power of attorney papers document an alternate or substitute person who may also act on the beneficiary's behalf or replace the originally appointed representative, we must receive documentation showing proof that the originally appointed representative is deceased or that the person is no longer able or willing to act as the power of attorney. We cannot add an alternate or substitute representative without supporting documentation. The exception to this is if the document clearly explains that all parties appointed to act as the power of attorney share all responsibilities of the document equally. Power of attorney can sometimes be used to appoint an executor of the estate based on wording prior to the patient's death. All POA information terminates upon death of the patient unless the document indicates that an executor of the estate has been appointed or established prior to the appointing person's death. There are some commonly seen documents regarding POAs, guardianship papers, trusts, and wills. These include a general POA, which is a written authorization to represent or act on another's behalf in private affairs, business, or some other legal matters. The person authorizing the other to act is the principal, grantor, or donor of the power. The one authorized to act is the agent or the attorney-in-fact, or attorney for short. This type of POA terminates upon incapacitation or death of the grantor. A durable POA is like a general POA, however, under common law, remains effective or durable even if a person becomes incapacitated. The only thing that distinguishes a durable power of attorney from a regular power of attorney is special wording that states that the power survives the principal's incapacity. In effect, under a durable power of attorney, or DPA, the authority of the attorney-in-fact to act and or make decisions on behalf of the grantor continues until the grantor's death. A medical or healthcare POA. This particular affidavit gives the attorney-in-fact the authority to make healthcare decisions for the grantor, up to and including terminating care and life support. In many jurisdictions, a healthcare power of attorney is also referred to as a healthcare proxy. This type of POA does not authorize the agent to make any legal, private, or business decisions. It is limited to only medical care decisions. The healthcare POA may grant the designated person rights to change and update the grantor's medical information, including address. However, this authorization must be expressly stated in the document. Medical power of attorney or healthcare power of attorney documents can only be accepted to release protected health information or claims-related information if the document includes a HIPAA clause. Without a HIPAA clause, those documents only allow the appointed representative to make decisions related to medical treatment. A trust or declaration of trust is a document signed by a trustor or settlor that creates a trust in which assets or property are placed. A trustee, who may be the party who created the trust, is appointed to manage the trust. The powers and duties of management of the principal and profits of the trust are stated, and distribution of profits and principal is spelled out. Declaration of trust documents cannot be accepted to release PHI or claims-related information to anyone. Declaration of trust documents allow the appointed representative to make decisions related to property. The only time trustee documents can be accepted is when the beneficiary is deceased. When the beneficiary passes away, the successor trustee is essentially the executor of their estate. If the person who created the trust is still living, the trustee has no power. Sometimes successor trustees are enacted in the event of an illness or disability. However, this is only for financial purposes. Since trusts rarely, if ever, account for HIPAA laws or government benefits, a trustee is not considered in effect until the beneficiary is deceased, at which time the trustee is executing the estate through the trust. In order to update the beneficiary information to release information, keep in mind that authorization to disclose forms must have the following: first and last names for who is giving authorization, as well as to whom the PHI can be disclosed, a description of the information to be used or disclosed, an expiration date, time period, or event that limits how long the beneficiary's PHI may be used or disclosed to the identified individual, a statement explaining the beneficiary's right to revoke the authorization, and the beneficiary's signature and date of signature. In order for power of attorney, probate, guardianship, last will and testament, conservatorship, and durable power of attorney papers to be used, they must have the signature of the patient, representative, or court or legal official on the paperwork submitted. The authorization to disclose form can be found at TRICARE4U.com by selecting the Contact Us heading and then clicking the link to the Forms page. The form is labeled Appointment of Representative and Authorization to Disclose Information. This form is provided to TRICARE for Life beneficiaries to meet the criteria indicated. When there is a death of a beneficiary, TRICARE for Life must obtain the information regarding who is authorized to act on behalf of the estate. TRICARE for Life must have this information on file to release information on the deceased beneficiary's estate. The information you are asked to provide on the estate notification form is as follows: the name and sponsor number of the deceased, who is the legally appointed representative of the estate. If there are legal papers showing court-appointed legal representatives, those must be submitted. If you are not the legally appointed representative, please provide your name, your address, your signature, the deceased's name, the date of death, your relationship to the deceased on the TRICARE for Life Executor/Executrix of Estate Notification form. Also provide the name and address of any additional representatives. Refer to TRICARE4U.com to print the TRICARE for Life Executor/Executrix of Estate Notification form. TRICARE for Life does not require a death certificate to be submitted. Please do not submit original documents if submitting legal appointed documents regarding the estate. Thank you for attending this webinar. Please be sure to look for us on Facebook and follow us on Twitter for information on upcoming tutorials and webinars.